Has it only been a week? This is the midweek edition of Legal AF. We do it one place on the Midas Touch Network exclusively. And we got to talk about at least three major topics today that'll take up the bulk of our time, along with anything else that my esteemed colleague and I, Karen Freeman McNifflo, can come up with. One, we're going to talk about Judge Maran, who is is going to have to make a Solomonic decision soon about whether and how to sentence Donald Trump for a 34-count felony conviction related to business record fraud in the state of New York. And in the interim, as we expected, he made a major decision about the gag order, or the double gag order, in advance of the debate. And we have his 5-page ruling, which I thought, again, was Solomonic and mature in how he handled it. Exactly the opposite of what MAGA and the world of MAGA tells their listeners and followers is the judge's temperament. And we're going to break it all down. And then we're going to find out, as Karen and I debate this, whether she's on the Norm Eisen school of sentencing, or she's on my world, or something in between. And that's what always makes for a great podcast. So we'll do all things Judge Maran. Then we got Judge Cannon. Judge Cannon went from she's like a crocodile in the Everglades as you're riding by. Or an alligator, and they're really sleepy until they, reach up and bite your leg off. And she went from sleepy to really aggressive in both scheduling hearings. She just had round 2 of like another half-day hearing in Fort Pierce. And she's giving as good as she can get, and she's taken on Emile Beauvais, fresh off his 34-count conviction of his client in New York, arguing for the Trump side, and taking on a couple of different prosecutors. But it's become like Cannon versus the prosecutors, which is never a good place. And I want to hear Karen's opinion, of course, but I've been in a situation where I've thought, and I won't name names, I've thought the judge was a little off kilter and not making good decisions, and maybe not even that bright. But you can't let the judge know it. And we're going to talk about the demeanor of some of the prosecutors who have gotten sideways with Judge Cannon, and whether that's a good thing, a bad thing, or a neutral, agnostic thing, as she decides whether she's going to suppress all of the evidence that was obtained during the search warrant execution, because maybe the search warrant was faulty, the execution was faulty, the chain of custody was faulty. I mean, you name it. Donald Trump's throwing everything at the wall to see if anything will stick. Is she buying any of that argument? Is she buying any of the argument that was done the other day about whether the independent, well, he's not independent, the special counsel is too independent from the Department of Justice? That's a new one. And his funding is not properly supervised by Congress. And therefore the judge should just pull the plug on the special counsel and find that he was improperly delegated to his authority and his funding. We'll talk about all of that. And then it's drop day for the United States Supreme Court. They're spoon feeding us their decisions as they hold back the 2 that we're waiting on, which is the immunity, whether Donald Trump has it or not, for any aspect of the Jan 6th insurrection or his attempt to cling to power, and whether he's going to be charged with 4 counts or 2 counts, or along with 300 other Jan 6 defendants. We've got some idea from some decisions rendered by somebody like Gorsuch about what might be coming. But more importantly, instead of getting those decisions, we got one that's another screw up acknowledged by the United States Supreme Court in accidentally posting a ruling. This one turned out to be decent, about abortion and EMTALA, the Emergency Medical and Labor Procedures Act thing, about whether it overrides in Idaho what looks to be an absolute ban on abortion or not. We've got an accidental of the decision almost to the day of the Dobbs decision, which itself had been leaked several months earlier, which took away a woman's right to choose. What is it with this court and abortion and its IT department? We're just going to have to talk about what the ruling is there, which seems to be actually a decent ruling for once, and a weird combination of Supreme Court justices joining together. and some other decisions that have come out in favor of the Biden administration, including the one in which lower courts had said, oh, the Biden administration was pressuring social media companies to deplatform people, to deplatform unfavorable viewpoint First Amendment expression. And the Supreme Court, including a grouping here again of liberals joining with right-wing MAGA to give a win to the Biden administration. And we'll talk about that as well. And I want to hear Karen's view. And we're seeing some of the Supreme Court justices sort of right on time starting to spread their wings. And I'm looking at you, Amy Coney Barrett, because all of a sudden she went from, well, she doesn't participate much in oral arguments and she's rarely in a dissent. All of a sudden she is, this term, in the last gasp of the term, is coming into her own, good, bad, or indifferent. We'll talk about what that means. It's about right. It usually takes a Supreme Court justice a number of years, unless you're Ketanji Brown Jackson, where she, like, day one was active, writing dissents and concurrences, but most of them wait 2 or 3 years. And we're going to talk about what we may be seeing with Amy Coney Barrett and what we may be seeing with Gorsuch and what it means for the future of decision making on the United States Supreme Court. But that's what we're doing midweek. And then later at the end of the week, Ben and I will pick up with the rest of the dribs and drabs release of the United States Supreme Court decisions. And we may have a filing, which I think is due in the sentencing issue related to Judge Merchan, but we'll pick up all that on Saturday. But Karen, wow, just 3 topics picking up, just this is why we do the midweek. Ben and I used to do like 12 or 14 topics. And it was like, it's too much. We need help. And we need another great person on this network. Oh, look, there she is. Karen Friedman-Knipolo.
Yeah,
there she
well,
is. Hi,
talk about bearing the lead. Okay. Yes, these are all great things that are happening, but even much bigger than all of that is you are 48 hours into being Big Poppy. You're your daddy. Look at her.
There's Francesca. We had a baby on Monday. We brought a little girl into this world, which I can't even tell you. I'm going to cry during this podcast. Oh, there's our release today. That was today. From shout out to Morgan Stanley Children's Hospital up in the Heights, up in Fort Washington. What an amazing group of people and dedicated healthcare providers and nurses, doctors and staff. I mean, it was just, it was our first experience, but an amazing experience. Thanks for letting me show Francesca, Madeline, Popak. So I know somebody wrote in one of the social media posts, why didn't you call her like something like AF, like Anna Francesca? I'm like, no, we're not going that far. I love the network.
It's just, she's so beautiful. And you have such a beautiful family. And the fact that you're here today after this happening less than 48 hours ago, or about 48 hours ago, is just a testament to you and your beautiful wife and your beautiful daughter. And just welcome Francesca to the family. And from now on, you're going to be Big Poppy to me.
Yeah. And your Aunt KFA, you've been tremendously loving and supportive and appreciative. And it's been a big help from the beginning. We won't go into those details about it all. And they're all paying dividends now. I had one funny intersection, not of law and politics, but of labor, the birth of the daughter and the show. So we're with this great Kathy. Shout out to Kathy. We had a great doctor, Dr. Fiorelli. Love her. And our birthing nurse was a woman who's a traveling nurse from Chicago area who's had retired and then became a traveling nurse effectively to travel, but she had been a professor of nursing and all that. So this was like the creme de la creme of a nurse. And she, like, just moments before we're about to go into the push phase, she said, oh, your wife told me about your show. I'm sure my husband, who, listens to all these YouTube things, what's the name of your show? And like during a break in the action, she actually phoned her husband and he's like, which one? Is it Ben or Michael? She said, it's Michael. Oh my God. And it was just a weird moment. And then it was like, okay, let's start pushing. But we're here now. All right. So listen, let's jump right in. That I really appreciate, and I appreciate everybody in the legal AF world and the Midas Touch world who have been so overwhelmingly loving and supportive of it. We're not going to make the whole podcast about this, but I do appreciate it. But how could I miss a show? I joked with Ben on Saturday that like my daughter already has exquisite timing arriving after Saturday and before Wednesday. And then I can't like not show up. So here we are. And I do have a supportive wife. All right, let's talk about Judge Maran, your old stomping grounds, the Manhattan DA. It basically came down. Let's do the gag order first. It basically came down to there's three components of the gag order. One was about jurors. Don't go after jurors. This seems ridiculous that we have to have a gag order that says that. Don't go after jurors. Don't go after certain elements of the criminal justice system. The judge's staff, but not the judge and family. The DA's, the lawyers working for the DA's office on the case, but not the actual Manhattan DA. This was very, very surgically made and created by the judge. That's two. What's the third one, Karen? Two is judge, jury. I mean, we said we did jurors. We did the judge and the staff and
the family members
and family members, right? And so
witnesses.
Oh, right. All right. Oh, thank you. That was the major one that was missing. Sorry, that's where the brain. I do already have baby brain and witnesses in the case. And the case is over, but Donald Trump is now a convicted felon, and there's appeals, and there's still sentencing, and so there's still some need for a gag order. Your old office pushed for. Yeah, we're all right with not going at. I think they were okay with the witnesses, right?
Yes,
right?
yeah, they were fine. They were fine with the witnesses. I mean, look, the law.
Take it from there. Go over what they were okay with, and then what the judge ultimately did. And I can read a little bit from the order too. Okay.
Yeah. So look, they had to follow the law, and the law clearly shows that it's about protecting the integrity of the proceeding, and the proceeding is over with respect to the witnesses and the jurors. And the judge was clearly pained by this. He did not want to have to lift it with respect to the jurors, but he felt he had no choice given the fact that the trial and the part about protecting the integrity of the proceedings are over. But he did say that there's still a sentencing. And so that part, when it comes to staff and family members and prosecutors who are not the Manhattan DA and who's not Judge Maran, that's fair game. And so for that can still remain as a gag order. So he had to lift it as to the jurors and the witnesses, so Michael Cohen, Stormy Daniels, and you could tell he was reticent about the jurors and having to lift it from with respect to them because of the law. He said it would be this court's strong preference to extend those protections, but he felt the law required him to drop the restrictions. So you could tell he was conflicted about the juror part of it. But, the witnesses, he's always said that because Michael Cohen is so vocal about speaking about Donald Trump, that could be an area where he would lift the gag order. And now that he's no longer a witness. And Stormy Daniels, her response to this was quite dignified, I have to say, and really lovely, where she just basically said, I respect the judge, I respect the process, and it is what it is. She wasn't, for example, coming out and calling him names the way he calls her names, like horseface. But so that's where we are, and the gag order will remain as to the prosecutors and their families and the court staff until the sentencing July 11th.
This one's going to have on that one. This one's going to have an impact not just on the debate. Now that Donald Trump is freed up within those limits, it's going to have an impact on what, and we'll talk about it next. But I'll just tease it. In Mar-a-Lago, because the government, the Department of Justice, is arguing that Donald Trump's arguments that the FBI was trying to assassinate Donald Trump because they properly brought their guns with them to Mar-a-Lago while Donald Trump was in New Jersey, that actually put a target on the back of the FBI, and knowing his followers and cult followers and the violent rhetoric that usually triggers something to happen that puts people in harm's way. But the judge, we're going to talk about it next in the gag order, is not only has asked, for some briefing about the gag orders in other places. This ruling is going to put some wind at the sail of the Trump people to try to convince the judge that they should lift the gag order or not impose a gag order or further gag order in Mar-a-Lago. There's other problems with Mar-a-Lago, but this gag order, but it was the right thing to do. I mean, the judge, my favorite part of the decision and order, the D&O, the Judge Maran just did in New York, is in his recitation of how we got here, including that he, has won all the major issues at the appellate division, which is his bosses at the appellate court, even though Donald Trump and his minions like to run around saying, oh, he keeps losing at the appellate division. The judge keeps getting reversed. He never gets reversed. And that has not happened here at all. And the judge reminded that of the recitation. But then when he gets to the date order of things, my favorite part is and he has to write this. It just, I'm sure drives Donald Trump's people up the wall and batty. He says on page 3, on May 30th, 2024, defendant was convicted of 34 counts of falsifying business records in the first degree in violation of Penal Law 175.10 after a trial by jury. Thereafter, the jury was discharged and the case was adjourned to July 11th, 7/11. Very unlucky date for Donald Trump. For sentencing. He has to say it, but anytime you can put Donald Trump in his place to remind him that he's just the convict, or will be soon, and a judge convict is great for me. And the judge did exactly what you would expect a proper, sober, as you said, applying the law type of judge to do, which totally which totally turns on its head all of the counter arguments by the minions that if I hear Elise Stefanik say this one more time, his daughter works for Democrats, and okay, he got sanctioned for, this was the House resolution. He got sanctioned, Judge Maran, because he gave $15 to Joe Biden. He got a warning letter along with a million other judges that they don't, the Judicial Ethics Board doesn't like any donations at all. So don't do it again. But it was like $15, and all this other stuff. There's nothing in Judge Maran's record on the bench for over 15 years, his prior history as a prosecutor, how he handled other cases before he got assigned this case, how he handled another case involving Donald Trump, the rulings that he made as they were affirmed by the appellate court, that says that he is anything other than a judge with a proper temperament, making appropriate decisions that will not be reversed on appeal and will not end up at the United States Supreme Court. I mean, I will talk about that when we get to the Supreme Court today. But there's a lot of fear mongering because it's distracting, because it sucks the air out of the room of what should be talked about by MAGA right on cue when Donald Trump pushes a button, that the Supreme Court should intervene after the conviction, and with Congress is asking, MAGA Congress is asking to do. It's not happening. Supreme Court is on summer vacation, and they're not getting back together again to talk about a garden variety criminal case about a guy who wasn't even president at the time he was convicted. Oh, all right. Let's talk about sentencing. Karen, you lead on sentencing. Norm Eisen, who's a close friend of yours, you've had him on your I almost said your award-winning. It will be your hard-hitting, rating-grabbing, amazing new show called Mistrial. Thank you, Salty. Right on clip. Thank you. Mistrial with you and Danya Perry and Kathleen Rice. You've had I don't know if you had him on there, but I know you did an interview of Norm Eisen, and I know you respect him greatly, as do I. He's got a whole thing out on Just Security about analyzing all the cases that he thinks fall into the bucket of a Class C felony similar to business record fraud, and what happened in terms of sentencing and jail time, and sort of argues that the judge should impose jail time. I don't know if that's 1 year, 6 months, 4 months, 5 days, but some sort of jail time. Where do you fall along the spectrum as we move into it? We're going to see briefings soon, and we're going to know what the probation department is recommending. But where does KFA fall on this continuum?
It's funny. I'm usually very decisive and I'm very clear, and I don't change my mind very often when it comes to things like this. But I have an evolution when it comes to the Donald Trump sentencing. I went for a period of time where I thought, what Donald Trump should get is some kind of, it's called the conditional discharge, and which means you get certain conditions. And the conditions I would impose on him, in my head, what I thought would be some sort of community service, like picking up trash on the subway, because a fine doesn't mean anything to him. probation would do nothing for him. And so that's what I'd want to see him do. I'd want to see him do something that's really not fun for him, like maybe 100 hours or 500 hours or something like that of community service. So that's what I originally thought, because probation makes no sense. Supervising him where he shows up at a kiosk and all the probation things made no sense. And I didn't think logistically jail, how would that work? And so as a result, I defaulted to this community service. But then when Norm Eisen, who did a study of every single case of Class E felony falsifying business records, he surveyed the state, because this is not unlike what Donald Trump likes to say, that this never been done before, never been charged before, first time. No one's ever seen anything like it. He makes these ridiculous pronouncements. And that's actually not true. Falsifying business records in the first degree is a very common charge that is prosecuted regularly. And it's a Class E felony, which means there's a wide range of sentencing options for a judge. On the low end, it could be nothing. It could be probation. It could be a conditional discharge, as I said. And on the high end, it could be an indeterminate sentence of 1 1/3 to 4 years, which means he can serve up to 4 years per charge, and they could run consecutive. They would all eventually merge to 20 years total is the total he could do. But he did a survey of all of the cases in New York State, because there are a lot where this is the charge, and looked at similarly situated defendants. And when you look at people who have been sentenced to prison, which is somewhere between, I'd say, 10 and 30% of the people, of the individuals who are charged with this exact crime. So the vast majority do not get jail, right? Or do not get prison. They get something less of that. But there's around 25% who do. And the question is, who are those people and why do they get jail time? And when you look at those cases and you see who actually has received jail as a sentence, there is no doubt in my mind that Donald Trump deserves prison, okay? He deserves it, and he deserves it in spades. Again, if you're going to treat him like everybody else, if you're going to treat him like somebody who committed the crimes that he committed, that was convicted of 34 counts of trying to steal an election, right? That's what the jury had to find beyond a reasonable doubt. That was one of the elements of the crime. The means and methods of how they did it is what they could differ on, right? It could be through the 3 different charges. It could be through state election crimes. It could be through federal election crimes. It could be through falsifying business records. It could be through tax methods. Like, the means and methods is what he said is what the law allows you to have a general criminal intent. But here you had to have it for it had to be unlawful purpose. And here they had to find beyond a reasonable doubt that it was election interference. And so because that is what they did, and because that was a requirement here, and that's what the jury found, how does it get any more serious than that? Because guess what? He stole it. He won by 80,000 votes in three swing states. What if this was the thing that got him to win that election in 2016? If that's the case, it doesn't get more serious than that. He's the guy who does deserve the prison time. And that's when I said, why are we all bending over backwards to try to come up with some other sentence for him? He should get prison without a doubt. It is as serious as it gets. He's convicted a full slate, 34 counts, okay? And on top of that, he was held in contempt 10 times for violating this judge's orders, 10 times. I've never in 30 years of prosecuting had a defendant held in contempt. It's not a common thing. This is not something that judges do every day. In fact, I was talking to a retired judge friend of mine today who told me in all his years on the bench, and he was on the bench for decades, he has never held someone in contempt. It is not a common thing. This is a defendant who just blatantly violates the law. The rules don't apply to him. He's convicted by a jury that he chose, okay? He was adjudicated a rapist by Judge Kaplan in a jury in that court. He was adjudicated a fraud to committed business fraud in state court in Judge Engoron's courtroom. This is a man who has a record like no other. And as far as I'm concerned, if I was a judge and he stood before me, I would sentence him to the maximum. However, I would it's called stay the sentence. I would press pause on the sentence pending appeal. And I would say, because look, it's a reality that there's an election and it is what it is. And there's something called federalism, and there's a federal election, and Article 2 dictates the presidency. And I'm not sure a state judge can put him in jail if he wins the election and becomes president. And so I do think I would stay, there are some appellate issues. I don't think he'll win, but there are. So I would stay the sentence pending appeal. If he wins, it is what it is. If he loses, guess what? Bring your toothbrush. You're going in. That's what I would do. You still with me, Pope? Big Poppy?
I'm here. Producer, put me back on the air. Popok's not gone. Where's Salty? There you go.
There
Salty,
you
you got to stay with me. I got a baby next door. You got to stay. If I step out for a second, I'm right back. I agree with you. It's sort of similar to what I've said before. I think he's gonna impose some sort of incarceration. Maybe have these other components to it. He's going to suspend it or hold it in abeyance until the appeal is over, which will get him over the November election. So he's not going to be able to be legitimately accused of election interference. I don't know. I've always thought it was somewhere between 6 months and a year. And how they do it, whether it's home confinement, an army base, something that's, constructed uniquely for him because the Secret Service has to be by his side. But I don't think he's going to give him like a pass. Well, I would normally, anybody that got convicted of 34 felony counts with the record this guy had and 10 violations of my gag order, I would just let him walk out the front door. I mean, that's not what Norm Eison's research says. He wouldn't do that. And I don't think it falls into that continuum of the ones that Norm had that listed like 1 day in jail, 5 days in jail. I think it's further down, like the female executive that stole $50,000 from her employer, and then falsified an invoice as a result, got like 5 months or a year. I mean, if that's the standard, or the exemplar, I think he should get a year or more, even as a first-time offender. But do all the other things that you just said. If he doesn't have to report, or it's abated until the appeal process, which could take over a year in New York, it's not going to be expedited. And if everything goes the way we think it's going to go, he's going to be a two-time loser for the office. He's not going to win in November, and he's going to shrink back down to size as a guy who lost twice after serving 1 term as president, having been twice impeached, 51 times convicted, and a judge to be a sex offender, and he'll hopefully crawl back under the rock that he crawled out under and go be a Florida man. Not our Florida man. Not the Florida lawyer guy. I think that's just what's going to happen. It's going to be the incredible shrinking Donald Trump, because he's going to lose, and that's going to be it. I mean, the MAGA movement will live on, unfortunately, as will all of his handiwork, all the devil's playthings, related to his Supreme Court and all of that. But I agree with you on that. So why don't we're gonna talk about Mar-a-Lago and what some of the rulings, it's like a cascade effect with some of the rulings that are being made by Judge Maran, how they're getting picked up down at Mar-a-Lago with Judge Cannon, who's holding her own bizarre hearings with, again, just to remind everybody, or for those that are new to this, she has not set a trial. She's just cogitating and analyzing her navel, and all sorts of things, but she's not getting a case on the docket for trial. Which is what really matters in terms of our public justice system. And we'll talk about how the Supreme Court is spoon feeding us the remainder of the last 12 decisions, until they give us, apparently on the very last day of in July, before they go off on summer vacation, they're going to tell us what we really want to hear is whether Donald Trump's DC election interference case in front of Judge Chutkan has a snowball's chance in hell at getting back up before the election or not. Yes, they have to issue these other decisions, but like And God forbid when we get a IT mistake, apparently, and they posted early a decision about abortion and reproductive rights. Why can't they do that for the immunity decision? Although I'm almost not want to see the immunity decision. We'll talk about all of that and so much more with Karen Freeman McNiffalo and me, Michael Popak, in the midweek edition of Legal AF. But we got a great group of curated sponsors that Jordy and the Midas brothers helped put together for our network and for our show in particular. And now we got to take a break so they can support our pro-democracy movement.
Many people are surprised to find out that I'm 57, almost 58, and that I'm a grandmother. That's why I love this product, OneSkin. This is something I use on my face every single day, and it makes me look younger. I think that's why people think that I'm younger than I actually am. It's super easy to use. You just use it with any of your other skincare products in your skincare routine. And if you're like me, especially this time of year, you always wear sunscreen on your face. And this product, OneSkin, has a sunscreen that I use every single day to help protect my skin, but it also helps nourish my skin and repair my skin with this OS1 that they have, this specially designed ingredient. So I love it. It also, you use it on your neck area, and it gives you lots of protection, 3 different types, in fact, from their non-nano zinc oxide, their potent antioxidants, and their OS1 peptide, which is the ultimate defense against UV exposure, collagen loss, and cellular aging. So I absolutely love OneSkin. And what really makes the OS1 incredible is it's not just a sunscreen, but it really is scientifically proved to switch off the aging cells that cause lines, wrinkles, and thinning skin. They also have a full body product with sunscreen that you can use. And so it can help also the rest of your body, not just your face. So I've been using this regimen for a while now, including the facial sunscreen, and I'm really hooked. Don't just take my word for it. It has over 8,000 5-star reviews, was recently recognized by Fast Company as one of the most innovative brands of 2022. And my mother noticed. And if my mother notices, it must be true. She's actually said to me, "What are you doing to your skin? It looks so good." So for a limited time, you'll get an exclusive 15% off your first OneSkin purchase using the code LEGALAF when you check out at oneskin.co. Try OneSkin today to get this trifecta of protection for nourished, glowing skin. That's oneskin.co, and put Legal AF in as a promo code when you check out. It's the world's first skin longevity company. So by focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. Get started today with 15% off using code LEGALAF at oneskin.co. That's 15% off oneskin.co with code LEGALAF. After your purchase, they ask you where you heard about this. Please support this show and tell them we sent you.
Proper sleep can increase focus, boost energy, and improve your mood. Introducing Beam's Dream Powder, a science-backed healthy hot cocoa for sleep. If you know me, you know that Dream has been a game changer for my sleep, and boy, do I need sleep these days. I drink Beam's Dream Powder each night in order to get my optimal sleep. And I gotta say, I wouldn't be recommending this if it didn't actually help me. And today, my listeners get a special discount on Beam's Dream Powder. Their science-backed healthy hot cocoa for sleep with no added sugar. Better sleep has never tasted better. Now available in delicious flavors like chocolate peanut butter, cinnamon cocoa, and sea salt caramel, with only 15 calories and 0 grams of sugar. Other sleep aids can cause next-day grogginess, but Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, melatonin, and nano CBD to help you fall asleep, stay asleep, and wake up refreshed. The numbers don't lie. In a clinical study, 93% of participants reported Dream helped them get better sleep Beam Dream is easy to add to your nighttime routine. Just mix Dream into hot water or milk froth and enjoy before bed. Find out why Forbes and the New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, get up to 40% off for a limited time when you go to shopbeam.com/legalaf and use code legalaf at checkout. That's shopbeam.com/legalaf and use code legalaf for up to 40% off.
You better get out that Beam. You better get out your Beam Dream and get some sleep with.
I've been all the sponsors products help me one way,
exactly,
or another.
But now more than ever is all I'm saying.
Or as Salty said in our chat, Popox glasses always match our sponsors' colors. I try. I try.
Pink,
and for all the people in the chat who are demanding more Karen, I got great news for you. Besides the midweek edition of Legal AF, she has a new show. You should go watch it. I don't know when it is exactly. When is this show going down on a weekly basis?
Usually either Thursday or Friday. It's hard to pin. It's hard to pin us all down. So this week we have a really special guest, and they were only available on Friday. So
you don't want to tease the guest?
It's going to be Cy Vance.
That's your old boss.
Yeah, my old boss, the former Manhattan DA. So Cy Vance,
awesome.
and we have to do it on Friday. So we'll be dropping that Friday
on Cy Vance Day. Mistrial. For those that love Karen, for those that love Karen and me, it's the midweek edition of Legal AF. You're here right now. Let's talk about Judge Cannon in Mar-a-Lago. How did she ever get this case? Ben and I reported, or we talked about on Saturday, the new reporting that's out there that Judge Altanaga, as I anticipated, as the chief judge, made a couple of phone calls over to Cannon early on and said, it's not a good look. You got reversed twice by the 11th Circuit even before the indictment came out. Maybe you don't want to handle this case. And another judge, which if I was a betting man, I think is Judge Middlebrooks, and the senior judge in West Palm Beach, who also said, maybe you want to give it to a more seasoned judge. And no, I'm going to do it. I'm going to handle it. Somebody tried to criticize me and say, Popok, you can't get your math right. She's been a judge longer than 2 years. I didn't say she was a judge for 2 years. I said she had been a judge for a short amount of time at the time that COVID happened, and she had very little trial experience. Not that she's only been a judge for 2 years. I know who appointed her. It was Donald Trump, and that was back in 2020. However, we're here now. She's holding day 2 of her hearings on suppression. I'll just map it out, and then I'll turn it over to our resident former prosecutor. You got a search warrant, which, by the way, the last time we heard from poor Magistrate Judge Reinhart in Fort Lauderdale was when he issued the search warrant. Normally, so people understand, in federal court, in criminal practice, the magistrate does a lot of heavy lifting related to discovery, motion practice, things related to the search warrant, and the like. But I don't know if, because his ruling ultimately got upheld by the 11th Circuit and hers didn't, she put him in an icebox and hasn't let him out since, and has just decided it's just so important. She is the Article 3 judge, is going to make all the decisions in the case, which is really weird, by the way. And it gets her going in the wrong direction, and then she has no help from a more seasoned magistrate that could help her out in these things. So many times when you and I are talking about Judge Cannon, we should really be talking about Magistrate Judge Reinhart, but we're not. And that's part of the problem. And it's frustrating now to the prosecutors. So let me just give the prosecutor's frustration, get your view on that, and what's going on with the search warrant suppression hearing. So you've got all these hearings going on about the evidence that was obtained by the Department of Justice and the special counsel, including the 34 documents. That seems to be a number that Donald Trump has problems with. The 34 or 38 total documents that are the top secret classified documents that are at the heart of the indictment. And the search warrant, which was prepared by the Department of Justice, ultimately signed off by Magistrate Judge Reinhart, specified where at Mar-a-Lago they had reasonable belief, probable cause to believe there were documents related to a crime located. And Emile Beauvais, who, did an okay job, although they lost terribly at Manhattan DAs against the Manhattan DA, he's been arguing for Trump about, oh my God, they went into the personal bedroom of Barron, and they went into all these other areas, and it was the subpoena, the search warrant was too broad, and you couldn't follow it. And the judge was like, I don't know what you're talking about. Even Judge Cannon was like, I think this was about as reasonably articulated as the locations as possible, and it seems like they colored within the lines when they executed on the search warrant. And the fact that you're complaining about, they looked in a bedroom, they didn't find anything there, so there's nothing to suppress. In other words, they didn't go outside the lines of the search warrant and then find things they're trying to use here. Even Judge Cannon knew that is probably what's required for suppression. Oh, we found it under Barron's mattress. Okay, well, then we'll have an argument and discussion about whether they should have been in Barron's room or not. But when you tell me they were in other rooms, they didn't find anything, that seems like you're barking up the wrong tree, even for Judge Cannon. And we all know here on Legal AF and otherwise that they found things in weird places you wouldn't think because they were tipped off that they were there, like in the ballroom and in the bathroom and in dining rooms spilling out onto the floor. Well, look, I love Salty. Found pictures right there. I mean, yeah, it's and as the judge even said to Beauvais, she said, it's not like it's a regular like 3,000 square foot single family house. This is like a 50,000 square foot resort. And he's hiding documents everywhere, and that was the probable cause. So she hasn't issued any rulings yet. She's notorious for not issuing. That's why we never have anything. You notice when we do segments, we talk about real judges that know what they're doing. We throw up orders. We never have that really with Judge Cannon because we got no order to throw up. But we get where she's leaning. And then there's this back and forth that seems to have taken a turn with the prosecutors, who seem really frustrated with her. She got into it again, Karen, with Jim Harbach, who's one of the lead, Dave Harbach, who's one of the lead prosecutors. She's gotten into it before with others. She called him snippy. She counseled, she warned him that he wasn't exercising proper decorum. He wasn't treating her properly in the courtroom. He was cutting off her questions, and she wouldn't tolerate it. And she basically said at one point, and if you can't handle this hearing, there's other people on your team that I'm sure can. And he kind of woke up on that. But talk about it if you've ever gotten slightly sideways with a judge. But talk about where you think she's going with suppression, and then this sort of bad blood that appears to have developed between the prosecutors and Judge Cannon, whether it matters at all, or whether the appellate court's just waiting for something to reverse her on. Where do you come out on all this?
Well, let's just start with, there's people who often ask me, what is your podcast about and how do you prepare for it and all of that. And what I always tell everybody is, I go and I read the motions myself, the decisions myself, the transcripts, if they're there, myself. And I try to interpret them for people because the law can sometimes be complicated. It can sometimes be convoluted. And there's a lot of misinformation out there, especially that comes from Donald Trump himself and many of his followers who parrot what he says and lie for him, frankly. And that's what frustrates me. It's not about, I'm perfectly fine with people having intellectual discussions about things that, I think taxes should be higher. I think they should be lower, or whatever, all those things that people can disagree on and have intellectual discussions about. But here people lie and things are not true. And the reason I bring that up is because in all the cases that we cover, in all of the proceedings that we look at, there's nothing about Judge Cannon and the Mar-a-Lago documents case that resembles the practice of law as I know it or understand it. So it's hard for me to interpret because it doesn't, what Judge Cannon does is kind of lawless, frankly. It has no basis in the law, which is why she's been reversed multiple times by the 11th Circuit in this case, nor does it resemble anything that's familiar. And there's only one conclusion, in my opinion, is that she is auditioning for some other role in the Trump administration. And what she is doing is she is making, I think she's smart. I don't think she's stupid, and I don't think she's inexperienced. I think she's extremely smart. And I think she is not ruling on things and just holding them in abeyance and pushing them out, because if you don't rule, you can't be appealed. So there's nothing Jack Smith can appeal and go and try to get her reversed or even get her removed off the case. And all they're doing is delay, postpone, hope that he wins the election, and then you'll see whatever the reward is that she is going to get, because she is clearly auditioning for some other role. And I don't say that lightly. I don't say that about judges lightly. But there is nothing about what she is doing that resembles the practice of law as I know it. And I say that in the context of what you just asked and the questions you're asking, because she just held 3 days of hearings on things that are head scratching, that there should have never been a hearing about, that have no basis in remotely in the law. It was almost like an intellectual exercise. And to answer your question, have I ever become intemperate in court and lost my cool in court? It is very rare. Usually when you do it, it's deliberate, because it's a tactic. You don't want to lose control. But with Judge Cannon, I can totally understand, given how she has behaved and ruled and conducted herself in this case, why the prosecutors here would lose their mind, because unbelievable. I mean, just unbelievable. For example, we had hearings on whether or not the special counsel is appropriate, right? Just the fact that the appointment of a special counsel, the special counsel law, the fact that this is a law that exists, passed by Congress. We've had many special counsels. In many instances, it has been litigated 12 ways to Sunday. It has been upheld over and over and over again. Donald Trump appointed special counsel. Joe Biden has appointed special counsels. This is not something that is not within the law. This is not something that you certainly would hold hearings on, and that you would invite amici, right? The amicus briefs, these people, these friends of the court who have nothing to do with the case, but they wanted to submit their amicus briefs, right? And these are the I'm not a party, but I want to give you my opinion briefs. She said, okay. They asked to be able to speak in court, to talk and participate in oral arguments in court. I didn't even know that was a thing at the trial level. I know you can do that sometimes, rarely, but occasionally at the Supreme Court or the appellate court level, but that she would allow it here on an issue that's not an issue. This is like, is this okay? The concept of special counsels in the world. So it makes no sense that she would hold that hearing for any other reason other than to delay this case, right? Because it's clear when you look at the transcripts or the reporting from the transcripts, she's skeptical. She's not going to rule in favor of the defense here, but she's giving them win after win after win by holding these hearings and delaying. Yeah, she's wasting everybody's time. She is not ruling on, there's so many motions that she is not ruling on. For example, the CIPA, right? The Classified Information Procedures Act. There are multiple motions out there that need to be ruled, and in hearings that should happen, and evidence that should be taken at hearings, right? So that she can make rulings, so they can set a trial date. It makes no sense whatsoever. That 3 days worth of hearings. So another one she had was had to do with these. Evan Corcoran, if you remember, was one of the lawyers who represented Trump, and prosecutors are using some of his audio recordings and notes because when he represented Trump, because they said it pierced the attorney-client privilege with the crime fraud exception. She held hearings on that. Those were closed door hearings, so we can't really comment on what happened there. But that's something, again, already been ruled on. But let's have hearings. Why not waste more time? She held hearings on Trump's motion to dismiss the entire case on the special counsel thing that we were talking about. Again, she's never going to rule that, but what does she do? She's bought the Trump administration months of briefing and hearings, and now she didn't rule yet. So she's going to consider and cogitate and eventually rule. And I'm sure she'll rule that there's nothing that inappropriate about Jack Smith being special counsel, and the case won't be dismissed, but it doesn't matter because the case is never going to trial before the election or ever, because if she has her druthers, Donald Trump will win the election and she'll be appointed to some great position that she's auditioning for. And another thing that she held hearings on was whether or not there should be a change in the release conditions. This was a special counsel, Jack Smith, asked for change in the release conditions, saying that Trump, it's almost like a gag order. People are talking about it like a gag order, but it's really just tell him to stop lying about the search warrant affidavit and saying that that law enforcement could have assassinated him, that FBI could have they were going to assassinate him. It's ridiculous. It's BS. Oh, well, let me set a hearing a month from when you filed this emergency application, Jack Smith, and let me not rule on it. And, and we'll sit here and I'll hold hearings on it and waste everybody's time. And she did that again. And then the other one that she did that is just shocking is this whole thing about the search warrant. The defense is asking for what's known as a Franks hearing. I had to look it up because I've heard of it before, but I'm like, a Franks hearing? What's a Franks hearing? Because it's so rare. It basically means that you have to prove, the defense has to argue and submit evidence that the FBI intentionally misled the judge, the magistrate judge here, it would be Reinhart, when seeking the warrant to search Mar-a-Lago. It's like a bad faith, intentionally bad faith, like they did something wrong, almost committed a crime and lied under oath. They have no evidence of that whatsoever, but let's ask for a Franks hearing. It looks not, and there's no sanctions that she's giving to the defense for making these ridiculous, frivolous motions that are wasting everyone's time, that is casting aspersions on law enforcement that didn't do anything wrong. But she allows all these arguments. She allows these ridiculous hearings, and then she doesn't rule on them. And then the other thing that apparently went on in her courtroom in the last few days was this argument that the search warrant was overbroad, that they should have been more narrowly tailored. Why did they go into Melania Trump's living quarters or Barron Trump's room? And she wanted to apparently muse about what was the necessity of these things. And it's just the whole thing is just head scratching, frankly, just absolutely head scratching. So I'm not surprised that at the end of these contentious hearings that one of the prosecutors was frustrated and either intentionally or not kind of lost their cool, because there's nothing about this that resembles anything I've ever seen before.
Yeah, I don't. The two things that concern me the most of all this is the possible suppression of Evan Corcoran's notes and audio recordings. That decision, I thought, had already been decided once and for all by the chief judge at the time of the D.C. Circuit Court, Beryl Howell. There was no appeal taken of her decision to turn over that to the United States Supreme Court. We always thought that was sort of a waiver argument that could be raised against Donald Trump, but they've decided they've got a willing participant in Aileen Cannon, and Donald Trump's like, let's just keep throwing as much at her as we can. We're getting great rulings, or we're getting some rulings that help us. And what I see from the prosecutors is they think she's what was the word I was use the M word. They think she's a moron, and that it is slipping out during their. They're getting very frustrated. I think they're getting frustrated also because they're trying to find ways to go to a higher authority. They're trying to find ways to get back to the 11th Circuit, where they think they will have a very willing audience to reverse her. But she's an evil genius. She's finding ways, as somebody said recently in our chat here. Say what you want about her, Popok, but she's found a way not to issue an order since she got reversed twice, and there is a lot of truth to that pithy observation about Judge Cannon. So Evan Corcoran, they can win the case without it, but it helps the prosecutors make the willful, corrupt intent, mens rea connection to the jury so much easier, other than relying on grainy videos of, the two other co-conspirators lurking in the dark, moving boxes, and then getting, and circumstantial evidence is just as good as regular direct evidence. I mean, that's nothing wrong with that. All evidence is weighted by the jury, but just because it's a certain quality, a video is not greater than testimonial. Testimonial is not greater than something that's that's a document. But the jury weighs all of these things as they weigh the evidence. That's why they're the fact finders. So I don't want to lose Evan Corcoran, his 50 pages of notes and his audio recordings about Donald Trump giving him instructions to not turn over the documents to the government and make them disappear. That would be a good one. And the other one that really concerns me is that there's still mileage and oxygen left in this argument about the special counsel being properly appointed, delegated authority, and given a budget to operate. It's not, I want to be clear, this version of the special independent prosecutor counsel thing, we've had a version of it. Some have been actually created by and appointed by Congress. This is not that. The one that was appointed by Congress was the independent counsel, which we had the 1980s. And then finally, after Ken Starr made a mess of it and some other things, both Democrats and Republicans said, let's get rid of the independent counsel. Before that, we had a special prosecutor. And that came out of Robert Bork, who was the acting attorney general at the time during the Nixon administration, promising Congress that he would appoint somebody independent because of all the corruption in our last criminal presidency. That was Nixon. This, of course, that looks like child's play compared to what Donald Trump did. Oh, I long for the days of Richard Nixon being the president of the United States again. But, Bork promised Congress that he would appoint a special prosecutor. That was the name. There was nothing on the books of the DOJ, nothing in the Code of Federal Regulation. And the Congress was like, okay. And he appointed Leon Jaworski, and Leon Jaworski ended up prosecuting and convicting a number of people in and around Richard Nixon, including the then Attorney General. And he had a budget, and the budget came from the Department of Justice, and nobody said anything about it. And the Supreme Court at the time in 1974 recognized the validity of a special prosecutor being appointed by the Department of Justice and enforced his subpoenas and his subpoena power to turn over the now infamous Nixon tapes. That was special prosecutor, which is sort of a version of what we have now, but even more informal. And that was fine with the Supreme Court. Then you had the independent counsel through Congress. Then that got removed, and you had the creation of the special counsel, not prosecutor, created as it's a creature of the Department of Justice, and then ultimately the Code of Federal Regulation, which is adopted by Congress. So we do have the congressional input there, which outlines when a special counsel will be appointed or should be appointed by the Attorney General, and who it answers to and how it answers to it, and the oversight. And then the Attorney General at the time has oversight over him by the leading ranking members of the House and Senate Judiciary Committee about whether he's going to accept or reject the recommendations of the special counsel. And there's funding that comes from that. All of that is like settled law, as far as I'm concerned. Received wisdom, call it what you will. But as you pointed out, Karen, to Aileen Cannon, it's all like, this is fascinating. How much money, this was the last hearing, how much money is being spent, Mr. Prosecutor, on this? What does that have to do with anything? And by the way, 30 or 40% of that is for security protection, to protect the people that are on the FBI. And so prosecutors are now being asked how much budget is being spent on it. How much oversight is Merrick Garland really giving to? I mean, this is like anything that pops in her head that she finds interesting. And the prosecutors have basically drawn a line in the sand with her at the last hearing and said, if you're going there, we want more briefing on it, because no other judge, and including the Supreme Court, has ever found that we're invalid. And if you're going there and you're close to going there, just tell us now so we can take, no. And then, she always finds that way to back up back up and back off so she doesn't make a ruling. As again, as I said at the top of the segment, no trial date has been set. It's not like it would be one thing if she'd set the effing trial date, sorry, the legal AF and trial date, and then we worked backwards to fill in and backfill with these motion practice. I'd feel slightly better knowing, all right, well, there's a August 1st trial date, and we got to cram it. But when it's this terrible thing where there's no trial date set at all, and she just has this unlimited 10-mile long runway and nothing to police her or discipline her at all, or add discipline to the case. And that's why there's other judges in the Southern District of Florida, as I thought, who are pulling their hair out and they're turning gray, and they should use OneSkin or whatever the product you talked about tonight, because she's aging the rest of the Southern District of Florida. Because they're like, God, this is not covering our very once proud department or division of the Southern District with any glory. It's making us look like a bunch of yahoos in a backwater town, and that's her history. And like you said, Karen, and I've said before too, it's either she's going to get elevated by Trump if he wins, God help us, to like the DC appellate court. Wow, because she's an appellate lawyer by training, allegedly. Or if not, she's going to rotate she's going to leave the federal bench because she's killed her career one way or the other. But she'll get a lucrative job working for some MAGA law firm, or she'll represent MAGA. She'll make millions of dollars. She's not doing that now up in Fort Pierce, Florida. So her trajectory for her career, because she kept that case, has changed, whether we like it or not, right?
Yeah. Let me tell you something. I don't know that people recognize what an incredible encyclopedic knowledge of just information you have, Popak. I mean, first of all, we prepare a lot for Legal AF. We read briefs, we read decisions, we read newspaper articles. We do everything we can to learn as much as we can. You just had a baby. Today is the day your baby came home from the hospital. I am sure you did not do as much preparation as you normally do, but you just gave the history of the special counsel down to the year and what they were called, okay? It was a special prosecutor, an independent counsel. You talked about Nixon and all these other, I can't even remember half the things you just said. You have this is why I love doing Legal AF with you, because we are so lucky. Everybody is so lucky that you do this, especially days like today, where I can't believe you had time to do.
I'm going to match my glass color in a moment.
But it's really true. I know a lot of people. I know a lot of smart people. You have a gift, and you are so. It is such an honor to do this with you every week, and that you give so much time to everybody. It's just, it's fascinating. It is interesting, and I learned so much being with you. So I'm just blown away. Actually,
I don't take compliments that well, but I love you at the bottom of my heart, and I really do appreciate that. And how I feel about you. If people don't know, I had a choice to do this show with many, 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 many people, but after one deep conversation with Karen leaning up against the side of a building.
Well, I'm also bossy.
No, that wasn't bossy. You didn't boss me into it. I wanted to do it with you.
Yeah, well, I'm just saying though.
Yeah,
look,
I appreciate
it. I know what I have. I know what I bring to the table, but what you have is just, believe me, it is incredible. Like, that just blows me away. And you do that a lot about a lot of different things, not just about a few things.
We got to lean into our competitive advantages, and that's what I got. And I do really appreciate you.
Yeah,
and saying that.
Pretty great.
So we're gonna see how much more Popak's got to offer today. We're gonna talk about what dropped with the United States Supreme Court and what shouldn't have dropped, but apparently did, to the point where the actual Supreme Court had to acknowledge that the IT department had inadvertently posted a full-blown decision, this one kind of in favor, thank God, of reproductive rights and a woman's right to choose, in a way at least, but should not have been posted today and did. And then Bloomberg Law or Bloomberg News picked it up, and then you and I get to talk about it. And it's like eerie. It's almost to the day of when the Dobbs decision dropped, and you and I have our own unique connection to the Dobbs decision, because the day that you and I interviewed, it seems like a lifetime ago, but it was 2 years ago. You and I had Robbie Kaplan, we were going to have her on to talk about all things Trump, including E. Jean Carroll. She represented E. Jean Carroll, but she has a number of cases against Donald Trump, and is really a phenomenal lawyer and appellate advocate, Supreme Court advocate. She had done the Defense of Marriage Act at the Supreme Court, but the day that we had her on, we kind of threw away our script because the Dobbs decision in draft leaked, and we got our hands on it. We were all crestfallen and heartbroken about it, but we read it cover to cover, and we got Robbie to talk about it with us. And that was in March. And then in June, as we said, the actual decision came out. And now we got this new one about Idaho, of all things, and EMTALA, along with some other decisions. We're going to talk about all of that. The ones that have dropped that we can talk about, including a rare win, or maybe 2 wins for the Biden administration back to back, a weird decision about bribery, some tea leaf reading about maybe the Jan 6 defendants in Donald Trump and the obstruction of Congress, and then what we can expect, because it ain't coming today. It didn't come today, this week or next week, as we await the final last gasp of decisions to come and opinions to come out of the United States Supreme Court. But first, get ready, Salty. Sometimes you forget about our ads, and I have to remind you. But first, another ad break.
Don't tell anyone, but I'm actually a cat person. And I don't like cat food. It's disgusting. Either it smells bad, or those little hard, terrible things that with hard food that cats don't like. My cats don't love that food. And I don't like it either. I don't like giving it to them. But our next partner has truly made a positive impact on my little kitty cat, who I love, who you've seen jump into some of our podcasts or into my hot takes or even my ad reads. And I'm talking about my kitty, Cooper, who's just a sweetheart. And so I am so, so happy that Smalls is absolutely one of our great new sponsors. It's a cat food that is protein packed, and these recipes are preservative free, these ingredients that you would find in your own fridge. And it's delivered right to your door. And that's why veterinarians, veterinarians.org, they rate Smalls 10 out of 10 for ingredient quality. And when I gave Cooper Smalls, he loved it. He ate it all up, unlike those little hard, crunchy nugget, disgusting things, or that smelly food. He absolutely loved it. He prefers it more than he preferred his old food. And I even put side by side his old food and Smalls, because I wanted to see, is it true? I'm going to be doing this ad read. And guess what? Cooper chose the Smalls. Yay. So I love Smalls. It's definitely made it more pleasant for me to feed Cooper. And it also makes it so that the house doesn't stink like cat food. And I don't know, I just feel better knowing that I'm giving Cooper a really good quality with good ingredients cat food. So I love it. It's great. And I think he will love it too. I think you'll love this protein packed meal for your loved one too, if you love your cat as much as I love mine. So after making the switch to Smalls, 90% of cat owners reported overall health improvements in their cats. And I think that's a really big deal. This team at Smalls is so confident your cat will love their product that you can try it risk-free. That means they will refund you if your cat won't eat their food. Pretty great, right? So now's the time to switch to Smalls. Head to Smalls, SMALLS.com/legalAF and use promo code legalAF at checkout for 50% off, 50% off your first order plus free shipping. That's the best offer you'll find out there, but you have to use code legalAF for 50% off your first order. So that's promo code legalAF at smalls.com. That's plural, SMALLS.com for 50% off when you insert code legalAF plus free shipping.
Have you ever wished you had whiter and brighter smile? Well, before you visit a dentist, you should know that their whitening treatments can be very expensive, and it's not just the price. You also have to book an appointment, schedule the time away from work or family to sit in a dentist's office chair while undergoing a procedure. It's hassle, and fortunately, now you can try Smile Actives at home or anywhere, anytime. Smile Actives offers safe and affordable alternatives to those expensive whitening procedures. I have had bad experiences with whitening agents. It's made my teeth feel sensitive. I haven't liked the way it made me feel. I didn't like the taste. But Smile Actives makes a teeth whitening gel that you can simply add to your toothpaste every time you brush your teeth. So there's no change in your routine, no extra time, no more messy strips, trays, or lights, and it doesn't taste terrible. Simply add Smile Actives Pro Whitening Gel to your regular toothpaste. It's been formulated with polyclean technology to boost stain removal and deliver active whitening ingredients into teeth grooves and crannies and get better whitening. 97% of Smile Actives users in a clinical trial reported up to 6 shades whiter on average, all within 30 days. Smile Actives is for everyone who's ready to invest in the next level of self-care. Tap into the personal power that comes from having a bright smile. I care a lot about my smile. I take care of my teeth, and I use Smile Actives. Visit smileactives.com/legalaf today to receive a special buy one get one free offer with auto delivery plus free shipping and handling. That's smileactives plural.com/legalaf. Terms and conditions apply. See site for details.
My favorite part of the Smalls commercial was that I don't know if you did it intentionally or it was subliminal, but you actually started whispering about you being a cat person as if Boogie could hear you.
So the thing is, well, first of all, I'm an animal person. Okay. I love animals. I have dogs, I have cats, I have chickens, we have horses. I mean, we have goats. We actually have, I have all of those animals, and I love animals. I've always been an animal person, but deep down, I'm a cat person. I just am. And I love the dogs, whatever, but I partly whisper it because, women in particular get judged for being cat people.
Oh, is
right?
that why you did that?
Totally.
I see where you're going.
It's only as I'm getting older.
Oh, the cat lady. All right.
Yeah,
I see where you're going.
exactly. So it's only that I'm getting older that I'm more confident to admit that I am a cat person, but I do love cats. And let me tell you something. This cat food, and I'm not saying it's crack. You might as well call it kitty crack. My cat goes
Register trademark
for it. It is absolutely the cat. My cat loves it. It's actually incredible. I am sold.
So we had a similar thing in the marriage. We had the union of a dog and a cat when we got together. Natasha had Chanel, which I never in 50 years plus had a good experience with a cat. Starting with my grandmother who had this is politically incorrect. My grandmother who smoked 2 packs of Pall Mall a day had a cat named Smokey that was black. And, the first time I put my hand out as a 3-year-old, I got slashed. I think every other cat I ever had experience with, I somehow got ripped but wait a minute, not Chanel. So Chanel and it's my best cat experience ever. And then I had a dog at the time who passed. And now we have Lily. And we made it work, but that was our first attempt at joining a family together. It was literally cat and dog. I get you, and I like it. And I love our sponsors. I use Nom Nom for Lily.
Yeah, me too.
And
It's amazing.
she that Nom Nom face thing. She loves when I get that little bag out that with her, and it looks like real food. We left it out one day, and I was like, "Honey, what did you make?" She's like, "No, that's the dog food."
I would never, to be honest, I wouldn't promote these products if I didn't believe in them.
No. We
They
use them
send
all.
us, before we actually do these commercials, they send it to us. We try them out, and they're actually fairly amazing. But the cat food in particular I didn't expect it to be that incredibly. The cat absolutely loves the cat food. I've never had a bad experience with a cat. I've never had a cat that's aloof. I've never had a cat scratch me. I've never had any of that. My cats I've had cats my whole life, and they've all just been pretty amazing.
Hey, Smalls, no extra charge for the extended ad read today. Let's move on to SCOTUS. SCOTUS, we got another drop. Something else dropped. Every day you and I shudder to look at our text message chain to see what our producers have sent us that's dropped. We got a couple of decisions today, 2 official, 1 unofficial. Let's start with the unofficial because that one's more interesting. Idaho, in a case called Moyle versus the United States and Idaho versus the United States, Idaho has almost a virtual ban on abortion in Idaho. And we've been teasing, I hate that word. We've been talking about and anticipating this decision for a long, long time here on Legal AF. Ben and I have been talking about it. You and I've been talking about it in hot takes. What are they going to do when the Biden administration smartly used an existing law on the books under Medicare called EMTALA, the Emergency Abortions Law, to try to override and require that when medical necessity and the life of the mother is in jeopardy, unless there's an abortion, that an abortion is given in federally funded hospitals, regardless of whatever the MAGA was able to pass, or what law from the 1880s or 70s was triggered by the repeal of Roe versus Wade. We're talking about the life of a mother in labor, and an abortion being a medically necessary thing. So the Supreme Court got it, and we've been waiting to see it. Now, assuming that this holds, we've got a decision that's 6-3, and a very interesting grouping of 6-3 with lots of concurrences, and basically it looks like it's going to be a per curiam decision of the entire court with no author, but then a whole bunch of per curiams. You can see the lineup. So it's going to be Kagan and Sotomayor and Ketanji Brown Jackson, of course, in favor of EMTALA, requiring, even in a state like Idaho with a virtual ban on abortion, that a doctor give an abortion when it is medically necessary to do that, consistent with the law, the federal law. Thank Joe Biden for this. This is his way, having been dealt a terrible hand by the United States Supreme Court, trying to figure out a way to support women, try to make them less of a second-class citizen in this country when it comes to reproductive health at the hands of MAGA and the Republicans, and they already are doing it through executive orders. And then he just unleashed his administrative law team at every department to comb the books of their current existing federal regulations to find ways to support women and the right to an abortion under existing federal law. And one of them, a major one, was EMTALA. So you've got Kagan, Sotomayor, Ketanji Brown Jackson, but Amy Coney Barrett, she the mother of 8 children, apparently has joined this as well to allow abortion in times of medical necessity, along with Kavanaugh and Roberts. So that's the lineup. And then a weird new little grouping that has arisen in a number of cases now of Thomas Alito and Gorsuch against it. And Alito saying it's never been a medically necessary thing for an abortion to save a woman. Not only is he a white guy that apparently doesn't have any children making decisions about women, which is always consternating, but where does he get his science from? And I thought we weren't supposed to go to science with judges making science. I thought that was their whole problem with Roe versus Wade. Judges making scientific decisions and medical decisions, right? There's a federal law on the books. It either does or does not apply when a woman's in need. And so, but of course, you can always count on Alito and Thomas, but now Gorsuch, and he's done it a couple of times now, sides with them. So that's EMTALA. Why don't you tell me where you think, from the leak forward, what do you think it means from a reproductive rights standpoint, and if this decision holds? And then why don't you take the decision that just came out about, you want to take the decision on social media? Another win for the Biden administration? We'll divide it up that way.
Whatever you want.
Let's do it that way.
Look, the abortion leak, my friends who are Supreme Court appellate lawyers and kind of nerds, if you will, they say this was just a glitch. It was an accident. It was a technical glitch. It was not a leak. I don't know, not to be a conspiracy theorist, but I don't believe in coincidences. The only 2 times that that's ever happened were the 2 abortion decisions ever. I mean, it just seems a little too convenient, but whatever. Maybe it is just sort of a glitch or an accident. What upset me about this decision is it's a victory. Sort of. It's a good headline, but it's not a victory. It's kicking the can down the road. This was they issued a dig, is what they call it, which means it was dismissed as improvidently granted, meaning that's what it stands for, right? They call them a dig, and that's what the Supreme Court nerds call it. They don't issue them very often. It's usually one line, and it means, oh, we granted cert and we shouldn't have. This is not a case that we should have granted cert because these people didn't have standing, right? The few states and the individuals who sued didn't have standing. So we're going to send it back down, and you guys can kind of develop the record more, and we'll see if someone bubbles up that does have standing. And guess what? That'll be after the election, right? This is to me, this is going to be an absolute, and again, I sound like a conspiracy theorist, and I am absolutely giving my opinion right now, as opposed to when I read decisions and I'll tell people what they actually say. This is my opinion. So take it for what it's worth. It absolutely feels like this was, they know, the MAGA people know that, that this isn't going well for them, that women's, the abortion issue and all the women's rights issues that are happening, whether it's IVF, et cetera, not going well. Women are going to show up to vote soon. So let's kind of, we're not going to rule on the merits here. We're going to just kind of kick the can down the road. But it's coming. It's absolutely coming. They absolutely do not believe in abortion for medical necessity. It only has to be for the woman's life. And doctors were on TV today saying essentially what's happening is women are coming in. They are saying that there'll be a healthcare issue, a child that has an issue that will cause them to die in utero, but we'll wait for that. And we'll have to wait until you go into sepsis before we can intervene, because that's when it becomes medically necessary for you. And so what do? They have to send these women out of state to states where they can get the medical care that they want. So I think it's an outrageous, it's outrageous in my opinion. So I don't think it's a victory. I think it's just, kicking the can down the road, and we'll see what happens. We'll see what happens. Someone called it an ominous punt, which is what I think it sounds like. Really, this decision, this fake leak that was a glitch that I think was very intentional, or just a nice coincidence, is not great news. It's temporarily good news. But the case you wanted to talk about was Murthy. It's a MRTHY, and it basically was a 6-3 opinion where Alito, Thomas, and Gorsuch, this group that you said that you commented on, is coming together as a dissenting group, and they essentially said there was no First Amendment violation in the Biden administration asking social media companies to, flagging misinformation for them on either COVID or the election denials. And basically, there was a term that people are using. It's called jawboning. I don't even really understand what it means, but it's a term that is being thrown out there as the thing that the Biden administration was being accused of doing, that apparently they weren't allowed to the argument was that they weren't allowed to tell social media companies like Facebook, et cetera. And there were 2 states and 5 social media users that sued the executive branch, claiming that there was pressure for censorship, and essentially the Supreme Court said that it's okay, basically, and that this is not First Amendment. So it was a weird ruling that kind of left the door open for them to sue again down the road. But again, it's kind of another, this is another one where they said there was no standing, right? That there was no case in controversy. So I don't know. These aren't really substantive rulings. It's kind of, they're kind of these half fake rulings that the Supreme Court is saying on procedural grounds, I'm not going to rule on these things so that, so that we don't get criticized is what I think is happening. But they're not really ruling on substantive things. They're ruling on procedural grounds, which has the effect of leaving these things in place.
Yeah, all they need is somebody whose actual social media posting was banned by a platform, which they will then argue is because of pressure by the Biden administration. And then they'll have standing. And then I don't know exactly what will happen on the merits. I know from the oral argument in this Murthy case, Murthy's our U.S. Surgeon General, he got enjoined along with some others because he was going after fake COVID and fake health misinformation that was being put on the internet by internet trolls, Russia, China, MAGA, all the and killing people. And that sounds like a bad thing. That sounds like something the Surgeon General should be against. I mean, the Surgeon General just came out with a proposal to, and through the FDA to have social media have like warning labels on it and have children be banned from it, almost like it's a carcinogen, like a mental carcinogen. And, the way the MAGA and our Russian and Chinese trolls, who are masters of disinformation and brainwashing in order to pit Americans one against the other, and put us at each other's throats. So they're doing a great job with that, by the way. Shout out to the Russians and the Chinese who have figured out a way to activate and mislead great swaths of our country, including people, Karen, and your family and my family. But it'll just come back another day when there's somebody with proper standing. That's why I didn't get that excited about the decision, the last medicated abortion decision about mifepristone. I got it right. And we were like, oh, the headline that everybody had was like 9-0, like 9-0 on standing. It was just because this group of doctors never prescribed it, didn't treat anybody that had been harmed by it, and therefore didn't have standing. Or as Brett Kavanaugh put it in his so bluntly in his decision, what's it to you? You got to get over at least the what's it to you standard of standing, or you don't get into the courtroom. I thought that was like a New Yorker taxi driver. You're like, you talking to me? What's it to you? But it's like the bare minimum of what you need in order to have a ticket in the courthouse. I mean, we're not supposed to have, unless you're in Judge Cannon's chambers or courtroom, you're not supposed to be a complete stranger to the case and then be able to argue about it in a court of law. That's not our adversarial process at all, despite the existence of amicus briefs. So, and there was another decision on bribery, which sort of refined what bribes people can take that are in federal office that'll pass muster, and sort of delegating it to the local and state officials to figure out how much is too much when you reward a federal officer, a state officer for something, passing a legislation or something. I'm sorry, I'm old school. I don't think civil servants or people who are in an elected position in order to avoid public corruption should take anything. But, this Supreme Court's always finding ways to backhandedly help Donald Trump and his presidency of kleptocracy. And
Clarence Thomas. I mean, seriously,
yeah.
right?
Oh, right. Exactly. It's consistent with Clarence Thomas taking scads and gifts, right? You and I should get such a gift. You ever gotten a gift of an all expense paid vacation abroad in Europe and all the finest hotels and air? No, that's called the client. who pays you to go handle a case in that country or whatever.
Yeah, no, I mean, look, it's essentially, this case was about, is it a bribe? Like, is it a quid pro quo? Am I giving you something because I want something in the future in return? But it's okay, though, after you've already made your decision and done something as a public official, if you want to get a gift later, if someone wants to give you a gift, that's a gratuity. That's not a bribe. And that's what they essentially said. And I couldn't help but think, oh, okay, this was Clarence Thomas saying, hey, I don't, what are they going to do? Start saying that I'm being bribed with all these all expense, paid vacations that we're all getting? I mean, it's absurd. It's absolutely absurd.
Public corruption is a big deal and is a big problem. We got two major public corruption cases going on in my home state right now in New Jersey. Menendez, who got caught with his pants down and over the closet door containing gold I said gold bricks, containing gold bars. Yeah, that his then wife, and he got for helping an Egyptian businessman get the halal certification rights for everything going overseas in the military. A tremendously lucrative thing for which the Menendez family got a Mercedes and gold bars and everything else. And we got another major former executive in government in New Jersey who was basically taking bribes to approve real estate development rights and other things like that. And public corruption is a big deal. And those that practice, Jack Smith years before he worked with you, but when he was with the feds, he worked in public corruption, and that's usually a ticket for advancement within the Department of Justice. I don't know about the Manhattan DA's office, but the public corruption unit and those that head it, that puts you on the kind of the glide path for a lot of success if you're talented as both a frontline line prosecutor, the way that Jack Smith is, and as a sort of administrator and somebody that can put teams together and make them work efficiently. And you were both of those things, of course, when you were at the Manhattan DA's office, as was Cy Vance, who's going to be your guest this week on Mistrial.
Yes,
with Karen Freeman Igniflo and Tanya Perry, Kathleen Rice. So, and people always ask, how do we support progressive, pro-democracy legal shows that happen to be on the Midas Touch Network or on the Midas Touch Network, not by accident? And there's lots of different ways. One of them is we have different shows and ways that we contribute. I love doing hot takes. Karen developed a new podcast, and support us there. Watch us on those things, chat, thumbs up, comments, follow us wherever we go within the network. That's helpful. Karen writes a lot, for instance, on the Midas Touch website. I do less writing and more hot takes. We all do things that we're comfortable with, and in our ways, in our unique ways of contributing. Watching the show, being in here, we have a loyal audience. It's amazing. It's grown. We get anywhere between 14,000 and 20,000 just watching us do the podcast, and then, of course, watching the episode. We do it here, Midas Touch, free subscribe, help them get to their 3 million number before the November election. We're building this network with our own hands, as we like to say. No outside investors. Nobody censors us. They couldn't censor. They don't know what I'm going to say. They don't know what Karen's going to. I don't even know what I'm going to say at any given moment. So they couldn't possibly censor us. But we're not. We're unplugged. We're unfiltered. We're unhinged sometimes. But we're here, and we're doing our best on this network. So we also have the audio version. Some people don't even. Some people on the audio version don't know we have a video version, and vice versa. I've been told that by Brett and others on the network. They're like, some people don't even know we have a live version on YouTube. We have a live version on YouTube. And some people like to receive their information that way, and I get it. Some people know I'm in a car. I can't watch things, but I'm a podcaster. So we're on every major podcast platform out there. It's very easy to find any of the podcasts that we've talked about. And you can go back and forth, and you can subscribe. It's all free and like all of that. We've got sponsors, and it's not just like listening to the sponsors. If you're interested in the products, and we support them and we try them and we talk about them, then we've always arranged, negotiated some great deals to give you the opportunity to get these products, and that of course helps us. As you can imagine, it's a circle of life. We have sponsors, they sell products, they come back, and we're able to keep this whole thing going because we don't have any outside investors. And then we've got a Patreon that Ben and I created, where we're sort of at the intersection of law and politics, and we're doing the law part for people that want to geek out and nerd out on the law, but non-lawyers. Although we got a fair amount of lawyers that are on there too, or people that wanted to go to law school and all of that. And we do videos weekly. We do duets. We just did an hour-long live chat Zoom, Ben and me, where you got to ask questions and we answered them in real time, and that was amazing. And then we do tutorials. Ben just did one on the Supreme Court. He's going to do 2 more versions of that. I've done it on procedural and constitutional, criminal and civil issues from a practitioner standpoint. But again, the target audience is the same as our target audience for this podcast, which is just really smart, educated, interested, invested people. You don't need a legal background, although we do have, it's amazing. We do have a fair amount of lawyers that do like the show. So that's patreon.com/legalaf, patreon.com/legalaf. And if you come in at any level, the entry level is membership, it's $10 a month, and you'll get a lot of, I promise you'll get a lot of value from that. We had about 58 videos already up there that we've developed over the last several months. Patreon.com/legalaf. And then we've got a store where you can fly the flag of Legal AF, store.midastouch.com, for all our latest gear, t-shirts that partially was designed by Karen Freeman-Ignifilo, and all different shapes and sizes there and colors. And that's another way to support the show. So sometimes our personal life bleeds in to the show, and Karen's had some amazing events that have happened over the last year. This is now with Francesca. We figured out, I was talking to Jordy earlier today, this will be, by when Ben has his baby with his lovely wife Sochi in about 3 months, it will be the 3rd Midas baby in 2024.
Amazing.
Jordy went first, then me, and then Ben. Like boom, boom, boom. And and the love and support that we have has made this all of it possible. Karen's had some amazing events in her life, and we've all had some bad events that have happened during the year, but we feel like we can we're honest with our audience, we're authentic with our audience, and we're going to share with you where we are, when we are, and we might be in amazing moods, we may be covering up something else in our life but this keeps us going. And there's a reason I got permission to come on the show tonight from my wife, who's just right next door, because it matters and it's meaningful, and I want to be here. And I know Karen has gone through heaven and earth and been in places you guys didn't even know that she was doing the show from. And it's just a level of commitment and professionalism that I think is unparalleled on YouTube. But we do it for the legal AFers and the Midas Mighty, right, Karen?
Absolutely. Absolutely. There's nothing more important and nothing more worth it than being able to be here, and just that the people are here and want to hear what we have to say, and people are listening. And it's also building knowledge and building information. And I love when you talk, I sit here and I read the chats and just see how engaged people are. And just, they're really, really just, it's the thing that keeps us going. I know it keeps me going. Before we sign off, I just want to point out one really quick thing, if you don't mind.
Sure.
The Menendez case that you just talked about, Bob Menendez. The reason we get so frustrated about how Donald Trump is being treated differently than everybody else, I think Bob Menendez is a perfect example of that. He was arrested and charged, I think, 6 months ago. Okay, literally was 6 months before his trial started. That's how things normally go. Things don't normally, what the Judge Cannon is doing, for example, and what the Supreme Court is doing to bend over backwards for Donald Trump is just astounding. It's unprecedented and it's lawless. And I just want to point out the contrast, that the way that case is going and the fact that it's already on trial. There's nothing more complicated about Donald Trump's cases. He is correct when he says he's being treated differently than everybody else. It is true, but not in the way he means. He is being treated differently in that he is given, people are bending over backwards for him so that he is not held accountable. I just want to point that out because that shocks me.
And how about Hunter Biden? Hunter
Yeah,
Biden
exactly.
indictment to trial was under 8 months.
Exactly. There's
And he's got
another one.
another trial. He's not even done, the poor guy. I mean, talk about getting hit with both ends of the stick. He's got another trial in California that's even worse than this one in terms of he's facing in terms of sentencing if he gets convicted. That one's tax related, millions of dollars of tax issues he's got, and that one's going to trial before a year is up. That is, like you said, this is yeah. Donald Trump likes to say there's a two-tier system of government. He's right, but in his favor, not the other way around.
Not the other way around. And these are just two examples of that are just right before everyone's eyes. They don't have to take our word for it. And that's why we get so frustrated and get so annoyed at what's going on. So I just wanted to point that out.
Tune in to Mistrial with Cy Vance, a special guest on the edition of Mistrial that's this week. And then join Ben and me on Saturday, where we're going to wrap up with whatever happened at the Supreme Court between this show and Saturday, just as we had planned, and then anticipate kind of future things as well on the Saturday edition of Legal AF. But until then, I hate to end the show tonight, but we got to. Shout out to the Mighty and the Legal AFers.